Okay, recording is in progress. We have once again an absolutely superb turnout, everybody. Thank you. Um, the primary aim of today's meeting is debrief, to debrief on what happened last week on Thursday and Friday at the sanction hearing, to kind of recap on some of the key outcomes and to talk about potential next steps. In addition, I'm really, really pleased that we have Professor Marcus Krebs with us. Professor Marcus Krebs has been a wonderful supporter of the Transparency Task Force's work for several years. We have a really good working relationship, and Professor Krebs is somebody whose opinion on a long list of technical matters I rate very, very highly. And those of you who saw the letter that the academics wrote about one of the potential outcomes from the sanction hearing, i.e., if the judge were to approve the scheme of arrangement, what could this mean for the economic system, for UK PLC, as far as attractiveness is concerned? What could the knock-on effects be? What could the systemic risks be? What could the contagion risks be? So on and so forth. And in a short while, as soon as I get a chance, I'm going to put into the chat the document that Professor Marcus Krebs, Dr. Shmulo, Professor David Llewellyn, Professor Steve Keane, and others wrote, just in case you haven't seen it. And after I've gone round all the Woodford 10 and those who were happy enough to speak at the event last week, I'm going to invite Marcus Krebs to talk about the letter, the key messages within it, and why he was very happy to be a signatory of it. We're also going to have Hock Chan with us tonight. As you know, Hock is 50% of the Isle of Man too. Hock's contribution and Barrister Damon Falkowski's contribution to the cause has been simply off the charts. It's been simply off the charts. Anybody who was there last week or anybody who saw it online will know that Damien Falkowski, our pro bono barrister, absolutely awesome job, an absolutely awesome job. And we're all so proud that we have the benefit of that kind of input. So in terms of a very, very kind of loose schedule for tonight, I am planning that we wrap this up by 7. So let's try to be as succinct as we can. We're going to hear from those who spoke last week, if they want to kind of briefly recap, very, very briefly recap on the headlines of what they spoke about. We're then going to go to any others who are in the Woodford 10. I'm then going to invite Professor Marcus Krebs to talk about his views on that letter and why he was happy to co-sign it. And then we'll open up the discussion for probably the last 20 minutes or so. And at the very, very end, I'd like to hear from Hock Chan, who is without doubt not just an incredible retired legal brain, he's also wonderfully good at campaign strategy and all kinds of things. We really have been phenomenally impressed with Hock. So brace yourselves, folks. It's going to be an interesting 56 minutes that remain. I'm going to go first of all to those folks who are here that spoke last week. And we're going to go to Mr. Alan Pyatt first of all. Can I please invite everybody to applaud everybody that contributed last week? Alan and all the others, well done. You all did an absolutely phenomenal job. You really did. Alan, no time to kind of revisit what you said, but if you can just kind of condense it into a couple of minutes, tell us what you said to the judge. Thank you.
Well, that's a lot I said, but there's a couple of things I'd like to say about the whole experience.
Please do.
Being in court twice, both on 10th of October and last week, I think courts aren't the best place to have these sort of arguments because it's all a bit one-sided. They get to speak, we get to speak, they get to speak. And I know Damien had a little bit at the ends, but you know, it's all a bit skewed. And I think it'd be a lot easier to get the judge, 4 or 5 people round the whiteboard and argue each point and get each point across rather than this 1-1-1, because you just lose the thread of what's going on. And I am concerned that, you know, the judge doesn't quite fully understand the gravity of what he will say. Yeah. Not just the, you know, a lot of people will lose a lot of money. And I don't understand how the FCA still in their final day said that we will be getting significant recoveries for all investors. Purely not true. We're all going to get 4 or 5p, maybe 6p out of a loss of maybe 40 to 55p. So, I don't know which way it's going to go. Fingers crossed, but I think we've done our best. Whether our best is good enough, we'll wait to be seen.
Alan, thank you very much indeed. That's wonderfully concise for you. Just like to sort of elaborate on the contribution that Alan made at the hearing, because from my recollection of what Alan said, he really focused on a number of key points: the quantum of loss issue, the inaccuracies of the 77p and the pound bit, the whole idea that the voting process was very clunky. Alan did a great job of critiquing all those sorts of things, and he has been a marvelous contributor to the Woodford 10
There's
over.
one thing I'd like to say, Andy, which still we don't have an answer to. It's
Yeah.
the cornerstone, it's the pillar of everything that Link have been talking about, is the FCA's 298 million. They say it's around liquidity. I've sent an email about it, and Graham Dickinson kindly sent another email about it. They still haven't quite cleared that at all. They've hidden behind other investigations going on. But as far as I'm concerned, an ACD has responsibility, not only for liquidity, but for making sure that the fund manager is keeping within the mandate of a retail fund, which Woodford did not do, and therefore they're culpable, even though the FCA seem to be saying, no, they're only responsible for liquidity. It's a massive issue, because that's what they've used in all their arguments and trying to hoodwink a lot of investors, which we found out about. Anyway, I'll pass over. Thank you very much.
Alan, thank you very much indeed. We're going to go to others who were there either online or in person. If you don't mind, Will, we're going to go to Will Durson next, just to get his kind of commentary on what he observed. Will was there, I think, for both days, Will, if I remember rightly. And then we'll go to others who were present, either in person or online. After Will, we'll go to Marty Farrimond. Will, anything you'd like to share? Thank you.
Yeah, thanks, Andy. Yeah, I was only planning to be there on day one, but it was so fascinating, and I was so impressed with Damien as well that I had to come back for day two, and I'm glad. It was a pleasure to meet my fellow Woodford 10 in person. It's more than 10 now, anyway, but it was great to meet a few of the folk. In particular, I'm not going to comment about the actual, who said what and the FCA's response and the Link response. I'll leave that to others. The one thing I would like to say is it was such a pleasure to meet Damien and Hock in person and to be able to thank them for their extraordinary efforts, as you say, on a pro bono basis. And actually, in the pub afterwards, I asked them over a beer, so why did you do this, and why are you doing this? And at the risk of embarrassing you, Andy, they both said it's because Andy asked us, and Andy is such a nice guy, and we couldn't say no.
Get out of here! Get out of here! Get out of here! Well, you haven't embarrassed me, and probably
and that's it from me, Andy. But I had to say that.
Well, you're a sweetie. You are a sweetie. We're going to go to, thanks, Will. We're going to go to Marty Farrimond, then to Deborah Clark. Deborah, we're just kind of giving everyone who was there and active a chance to share their thoughts on recapping what happened last week. So thanks, Will. You're very, very sweet indeed. We're going to go to Marty, then to Deborah. Thank you.
Thank you, Andy. Yeah, look, I've not got a tremendous amount to say. I was there in person on Thursday and watching every word online on Friday. So I guess my kind of feelings are I don't know what to make of it all. I'd be curious to see if Hock has any opinions on whether we can read anything into what's been said or whether we really just are in the lap of the gods and to which way the judge decides to fall on this one. It's obviously good that his reserved judgment, because it means he's thinking and taking things seriously. But it would be interesting to hear from Hock any views. And the other thing I'd do is echo what Will just said, is enormously grateful for Hock and Damien. As you can see, those that were there or those that were watching online, it is a legal process, and without legal professionals, it's really hard to make any impact. So we're immensely grateful for having their efforts to try and put our best foot forward.
Marty, thank you very much indeed. I've just seen Professor Marcus Krebs's note in the chat. Yes, I'll spend a little bit of time kind of bringing you up to speed. I know that you were very busy in Parliament yourself last week, and if you wouldn't mind, just tell everybody a little bit about your background when you come to speak, and also what you're doing in Parliament last week, because I want everybody to know, frankly, the calibre we've got in people like yourself being with us, Professor Krebs. Thank you very much. Cheers, Marty. All crystal clear. To Deborah, and then we'll see where we go from there. Thank you very much. Thank you.
Well, again, thank you so much to Damien and Hock for doing such sterling work. It was, as Martin said, without such counsel and legal representation, I don't think we would have had any traction really whatsoever. To see the 50+ lawyers on one side of the court just goes to show the means and resources and all the input that they have as opposed to Transparency Task Force. I think everyone did a wonderful job, especially those that spoke. It is an uphill battle, but I think it's important that our voices are heard. I think the judge seemed to be very mindful, very balanced, asked some really good questions, and I don't think really in those terms, not that I've got that much experience, I don't think we could have asked for a better judge, a balanced judge. So let's see what happens.
Deborah, thank you very, very much indeed. Okay. Now, before we go to Professor Krebs, I would just want to invite anybody who'd like to share their thoughts on what happened on Thursday and Friday to do so before we go to Professor Krebs. Mr. Ian Duffield, of course. Ian, please do take yourself off mute and share your thoughts as well. Thank you, Ian.
Yeah, hi everybody. The thing that really appalled me was on day 2 and the FCA's position. I absolutely understand it from Link's point of view, in as much as they were the bad actors here, and the position they're in now is effectively they're going to wind up. They've thrown what they feel is an amount of money in the pot that will, from their point of view, make this thing go away. And no matter what is said and done, the amount that they're putting in, that's going to be it. Whether they spend it on fighting a battle against any appeals or resisting appeals, at the end of the day, they're going to write off somewhere between 180 and 230 million. That's the end of it, and they'll walk away and then probably do it all over again. But to me, the incredible poor running here from the FCA, I mean, all of us here sort of knew that there were going to be other investigations going on. But for the FCA to stand up and literally the last words out of their mouth were, oh, and by the way, we've still got some investigations going on, another couple. We're not going to tell you anything about it. That's fair enough. It's sub judice. But, you know, wouldn't it have been wonderful if that had been put in the original scheme of arrangement information and pushed by FCA when they were promoting this? Because the effect of this is, and I understand all the points that were made about ricochet effects and all of that, and why Link are taking the position they're taking. But for the FCA to claim that they are here to protect retail investors and specifically consumers, it's the same thing. Well, they're here to protect consumers, and then to announce with no really official public announcement prior to what was said at the court that, oh, and by the way, we're expecting you to give an indemnity to other people, which means basically everybody who was involved, everybody that had their fingers in this pie or their feet in this trough, or snout in their trough to be more accurate. And we're expecting you to indemnify everybody so the rest of them can walk away scot-free, including Woodford himself and Woodford Investment Management. And you'll never be able to come back and get any sort of effective claim against the compensation scheme, which we're pretending is there to protect and compensate people who suffer because of the likes of Woodford. But in actual fact, it's a sham. And I feel very, very deeply about the FCA's disgraceful position on that. That's my view.
Ian, thank you very much indeed for sharing those thoughts so in such a forthright way. You always do. You always do. Thank you very much, Ian. Anybody else before we go to Professor Marcus Krebs? After Professor Krebs, we'll hear from Mark Bishop, I see, just joined us. Mark, we're just kind of reflecting on key points that came out last week. Then we'll go to Hock, and then we'll start bringing things to close at roughly before 7 o'clock if we can, folks, okay? Anybody else who was there or who attended online other than Mark Bishop and other than Hock Chan? Please wave at me if you want to contribute before we go to Professor Krebs. Okay, in which case, we're going to hear from Professor Krebs shortly. Marcus, as I said earlier, when you do speak, please do take time to introduce yourself. I want everybody to understand the depth and, frankly, the breadth of your areas of relevant expertise to the issues we're talking about. But let me tell you what basically happened. In my personal opinion, and obviously I'm not going to say anything that could be taken adversely against the court or any of the legal professionals involved, but the opposition attempted to minimize the significance of the narrative in the letter. I think on the last day, and I stress, I think on the last day, the barrister for Link, I think she used the word overblown, i.e. exaggerated. They wanted people to form the view that the concerns being expressed in the letter were exaggerated and overblown. I'm pretty sure the word overblown was used.
You're right, Andy, it was.
It was. Thank you very much, Ian. Thank you. And I can understand this. Obviously, from their point of view, the last thing they're going to want to stand up and say is, actually, these guys have got a really good point, and you know what? We'd rather not risk meltdown of the system. Let's not approve the scheme of arrangement. So perfectly understandable. It's perfectly understandable that they will take the position that they will take. It's a matter of fact that the judge had the opportunity to consider Dr. Andy Shmulo giving evidence verbally. He's in Australia, but he could have done that online. But having considered it, the judge decided against that. Clearly, I'm not going to do anything to criticise the judge. That would be wholly improper of me to do so. But what we've got now, folks, is a chance to understand a little bit better what the narrative in that letter was all about, and why Professor Marcus Krebs and others who have tremendous subject matter expertise in this space are genuinely concerned about the potential, it's a key word, the potential big picture downsides in the event of the scheme of arrangement being accepted. And I'll also bring you up to speed on one of our compliance consultant colleagues who's shared his opinions with me about the narrative in that letter too. But Professor Krebs, please take an opportunity. Most people here don't know you at all, although you've spoken at many TTF events over the years. Marcus, please take an opportunity to first of all introduce yourself. Just before we do that, folks, you know what I'm going to say. Can we please show our appreciation to Marcus and all the other professors and doctors who did what they could to get a very, very important message across at a very important time to that court. Marcus, over to you, sir. Thank you.
First of all, thank you so much, Andy, for giving me the opportunity to speak here and also the opportunity to assist you in this matter. Now, first of all, I think we had to declare that to the judge. I'm not an investor in any of these schemes. There's no conflict of interest, certainly from my perspective. And I've known about the issue for a while from the TTF and from the newspapers, specifically about the letter. I think it was last week, Sunday afternoon, that Andy reached out to me and said, can you help us, please? We need to put something together. So we started putting this together, and I looked at this. I didn't have any details, any particular details. I didn't have any court documents, case files, or anything. What was explained to me is simply what the letter focuses on is the removal of investor protections by the FCA and by Link. And I couldn't understand it, and I had to get my head around first of all, why they would be doing that, and also what it means from a systemic perspective. Now, in terms of introduction, I'm probably the least academic on the list of academics in this particular letter, because my background is really 30 years banking, financial markets, capital markets, credit rating agencies, NGOs. I've worked with the World Bank on a variety of projects. I'm an advisor to the United Nations in the regulatory systems and systemic risk space, have been doing this for the last 11 years now, and more recently, the last 3 years or so, I've developed a policy proposal and a UN declaration focusing on the impact of artificial intelligence, in particular when it's embedded in products. My background is risk management. Really, I've been doing that for 25 years now. And systemic risk and conduct risk, oddly, amongst others, which is why I couldn't understand where the FCA is coming from with this particular piece. So I'm not going to go through the letter itself in great detail, but I will raise some points here, which I think are important from my perspective. So unfortunately, or fortunately, who knows, I couldn't attend on Thursday because I was in the House of Parliament in a debate with another victims group that was part of the loan charge scandal, which is a scandal that's been going on for 8 or 9 years now, I guess, and is impacting between, there's different figures, 60,000, 100,000, I say it's probably 70,000. And one of the sister organizations of the FCA, HMRC, is deeply involved and implicated and probably culpable in all of this as well. So, you know, I know what it's like from a victim's perspective. And obviously, there's the post office scandal, which has been across the news all over the place. But if you look at the post office scandal, 2,000 people impacted, I think 900 or so convicted to date. Loan charge scandal, 70,000. And when Andy gave me the number for the Woodford scandal, 300 or so thousand retail investors, I was shocked, because this is, you know, this is big numbers. There's big money involved here. And certainly you would expect a regulator who's responsible for the stability of the financial markets and also for maintaining effective markets, competition and financial stability, ultimately, to do everything at their disposal in terms of the toolbox they have available to protect that market. And sadly, that doesn't seem to be the case here. But so I couldn't come on Thursday, and on Friday I was chairing a United Nations working group on one of the projects I'm working in. But my view is this, regardless of, I mean, the other party in this case will do what they have to do, because that is their position. That is not going to move. And also, I was quite happy in a way that it didn't participate in the actual court hearing, because I noticed, certainly in the debate on Thursday in the House of Parliament, when some MPs emphasized that there is a real keenness of the judiciary in the UK to be independent. So the letter wasn't meant to be to influence the judge's decision in the case, but the way I see this is it's meant to provide a backdrop of potential unintended consequences that could follow as a result. And as a risk manager, I've seen this so many times. It's a sort of house of cards example. You take 1 or 2 cards away and nothing happens, but 1 card too many, and a judgment in this case could be that 1 too many card, the whole thing collapses and falls apart very, very quickly. And then the other thing I thought is, with this letter, we collectively, as a group of academics and or practitioners who have been doing this for an awful long time, and who have been seeing that sort of siloed thinking that is probably going on here, where you have the FCA doing their own thing, Link Financial doing their own thing. There's no connectivity here. The letter raises questions, and the nice thing is, we as academics, we do not have to provide the answers, but we do have an opportunity to put a post, a time and point assessment into place that says, hello, you know, why don't you just stop, pause, and reflect a little bit before you make that ultimate decision, which could be going this way or that way? Who knows? Because it gives you opportunity to think through what could potentially happen and also play with different scenarios. Now, as a risk manager, I usually come up with base case, a worst case, a best case. Sometimes there could be 30 different scenarios in between all of this, but it is important to pause, reflect, and do adequate analysis. And I guess what the letter is saying, really, maybe the court isn't the best place to decide this, because once the decision is sort of baked in, cast in stone, it's very, very difficult to undo. You're setting a precedence here, and everyone else will refer to that. And you're also potentially removing any future protections for any retail investor in the UK. Keep that in mind. So the judge shouldn't be burdened necessarily with this kind of important decision. It's a bit like almost going to a judge in the High Court and saying, well, we've got a problem in the Red Sea. They're shooting at our boats. Is it okay if we shoot at them? And then the High Court, the judge said, yeah, that's probably okay. You can just shoot at them. It's a decision where I question, where should that really be sitting and who should be asking the questions? So you can see in the letter at the bottom of the first page, you know, the Financial Conduct Authority, as well as the PRA, Prudential Regulatory Authority, have they undertaken their detailed impact assessment? What happens if you remove those protections? What's going to happen in the future for further cases down the line? And obviously, the FCA is sitting underneath HM Treasury. The question is, you know, what's their view on all of this? And then from a financial stability perspective, I mean, there was commentary earlier on from some of the attendees. There was talk about liquidity, but if you talk about liquidity, you should also talk about financial stability, and that is an issue for the Bank of England. The Office of Budget Responsibility has been mentioned in here because there might be a potential impact on tax, tax efficiency. We've seen that with the post office scandal, where HMRC is pursuing some of the sub-postmasters for some of the redress funds or the monies they have received. Ultimately, Jeremy Hunt has been consulted of that. We are moving into general election territory. This will likely have a potential impact. We heard today that inflation rate has gone up. Some of the banks have stopped providing cheaper interest rates for mortgages, so they're going the other way again. Economically, this doesn't look very good. Politically, what message is this sending both within the UK if we remove core retail investors protections, but also if you look at other countries, if you look at Europe, if you look at the US, if you look at Asia, everywhere there's some sort of deposit insurance guarantee scheme in place. If you take that away, you know, what guarantee have investors and what risks are they taking? And then finally, this really came to my mind in context of the post office scandal and the loan charge scandal, but then also the gravity and the scale of the Woodford scandal that we have got here. How many missteps and miscarriages of justice can be afforded by the UK government? And what happens is if further down the line, they're finding themselves in a position where they have to pay redress and compensation to all the victims out of this because someone comes along. Why on earth did you do that? You should never have done that. And then the question is, of course, someone will say, potentially, didn't anyone say anything and ask that relevant question or that set of these questions? And I think that's exactly what this letter is. The people in the post office have experienced similar at a more individual level, where they rang up the Fujitsu service desk and they were talking, no, you're the only one. This doesn't apply anywhere else. It feels a bit like it's been said here, this applies just to Woodford, it doesn't apply anywhere else. Now, once you put that in, once you set the precedent here, there's probably, I mean, I'm not a lawyer, so I might be wrong on this, but there's probably no way of going back, and someone else will try to do exactly the same thing, and they will say, well, Woodford did it, why can't we do it now? It's a bit like the loan charge scandal, where they put retrospective legislation in place that all of a sudden can go back 20 years. And now other departments are trying to do the same thing, whether it's HMRC or Department for Work and Pensions or whatever. So we've got to be very mindful of these big picture, which I would call a strategic decision of a public interest nature for a country, in that case, the UK. Is that really what we want? And what are we signaling by doing that? Hence the letter. So all of that is, I think, I mean, I'm glad that the judge decided to take 2 weeks' time. I don't know what he's going to do in these 2 weeks' time. Hopefully, he's reaching out to all these, potential stakeholders in that case, and consults with them and see what they come back with. And if I was on the defendant side, defendant being your lawyers basically, I would want to see what that risk assessment looks like, what that impact assessment looks like. I would want to see what Jamie Hunt has said about this. I would want to see what the view of the Bank of England, I don't know who it is, and Bailey or whoever is in charge there these days, whatever their view is on all of this, because that I think is important. And maybe even if you don't get to see it in 2 weeks' time, there is of course an opportunity to do a freedom of information request later down the line to see what thinking went on in these organizations. So I think we've put an important stake in the ground. We've given the judge an opportunity to reflect, and it seems like he's reflected, whether just on the letter or all the substantive arguments that have been made as part of the case. But it'll be interesting to see what outcome of this is. Thank you for having me, Andy, and good luck to all of you. So I'm feeling for you, and it's awful. So hopefully you will get the resolution you deserve.
Marcus, thank you very much indeed. Can we please thank Marcus again? In fact, not just Marcus, but all the other professors and academics who stepped up and actually said, effectively what they said was, we've got a responsibility here as knowledgeable, informed citizens with our backgrounds to make these points so the court can be aware of them. It's obviously then up to the court to decide what to do or not do about it. But at least these guys can sleep well at night knowing that they said, iceberg ahead, folks. You may not hit it, but then again, you might. Thank you very much indeed, Marcus. If anybody has any particular comments or questions for Marcus, please put them into the chat. What we're going to go to now is, we're now going to go to Mark Bishop, who missed the first 10 minutes or so of the session. Mark was, as always, significantly contributing to events last week. Mark, please do take the opportunity to share with folk any reflections you've now got from Thursday and Friday. Any thoughts about next steps? And after Mark, we'll go to Hock, who in so many ways is masterminding all of our work in the space. I'm sure all of you are going to want to really listen to what Hock has to say. Mr. Bishop, to you, sir. Thank you.
Okay, thank you. So I'm not going to talk deliberately about the legal issues that were raised on Thursday and Friday, because Hock is a lawyer and I'm not. And it's much more important that he talks about those things than that I make a ham-fisted effort to do so. I will talk about one practical thing, and I will also talk about something that Andy asked me to talk about, which is what happens next. So the practical thing is that the judge said that he would, what's called reserve judgment, he would go and think about it for about a fortnight. So what that means is that roughly 2 weeks from last Friday, there will be a judgment. What he'll do is he will send the judgment around on an embargoed basis, which means it's confidential only to the parties that receive it. And he asked that our legal team nominate 2 or 3 people in TTF to receive this document. And we're receiving it so we can review it just for spelling mistakes and basic errors of fact, stuff like that, not to challenge the legal arguments in it. And it's going to end in me. As a result of that, we would be in a very difficult position legally, be in contempt of court, if we did anything like publishing it or even telling people roughly what's said within it. So what we're going to do is we're going to put a protocol in place that means that nobody can accuse us of that. Not only are we going to do it, we're going to make sure we can't be accused of it. So there'll be no TTF events about Woodford from the moment that we receive that letter until it's officially published. It will almost certainly not be mentioned in Transparency Times. if you email us about it, we may well ignore you. We probably won't post in the group for the Woodford Warriors. Or if we do, it'll be to be in a way that's very anodyne. We're very careful not to do anything at all that gives any indication of which way the judge has gone. So just to explain that little period of omerta, it's there for a reason, basically so we don't get sued or locked up. And particularly the most important thing, so that we don't bias the judge against us and have him think that we're a bunch of responsible so-and-sos, which would be a big problem if it gets to an appeal. So the next thing is to talk about the fact that there may be an appeal. We don't know who will win, so we don't know who it would be that might have a right to have an appeal. But I would just want to flag up that it is a possible outcome here. And I would just want to talk about a little bit of game theory, which I've discussed with Hock, and it may be right, it may be wrong. It goes like this. If you are Link, what happens if you lose? Do you want to spend a few million on appealing? Why would you bother? You've already sold all of the goodwill out of Link Fund Solutions, you bank the money. You've already accepted that that money is going to go to the creditors one way or another. Your insurer has already recognised the need to pay up, and you'd have to get the insurer to pay up your legal costs if you kept going. Why would you bother? I don't see it myself, but I could be wrong. I could see why the FCA would want them to. So the question is the FCA prepared to strong-arm Link to make it appeal if Link loses? I don't know. I also have thought, one of the ideas I've discussed is, would the FCA and Link come back with a better redress scheme? And better in inverted commas could be in two ways. One is a big chunk of the money that Link Group gets from selling itself to Mitsubishi Bank in Japan. Another way in which it could be better is that it has, just as there is a small carve out for the Wallace LLP clients so that they can continue litigation, so there could be a carve out for all of the trapped investors in respect of all claims against Link and third parties other than those relating to the relative losses due to liquidity. So they could create a better scheme. Again, I don't know what it would gain them, frankly. They've already sold the goodwill. Why spend millions of pounds on what could be another 6 months? Asking about with this, I personally don't see it, but I could be wrong. And if there is something of that nature, of course, it would be a victory for the investors because they would get more money because it would come from they could get more money because of money from Mitsubishi Bank or there being explicit access to the FSCS, and they would get more money if they were successful in pursuing other claims. So that would be useful. And another thing the FCA could do would be to say, well, okay, let's go down the restitution route with Link Fund Solutions. And in fact, in an email to me, one of their people, I think it was David Cross, said that's what they would do if the scheme was not supported by investors. Presumably they'd do the same thing if it was not sanctioned by the court. So they could go down the restitution order route. They could get you the full 298 million in respect of the liquidity thing, and you'd still have all of your other claims. They would also, at some point, have to order the FOS to release and deal with the many claims that are there against Link Fund Solutions, and we would see whether they're accepted or not, and the value for which they're accepted, all of which would be very useful information in terms of the quality of the other claims. The other thing is that they put themselves in quite an interesting position, I think, again, not a legal view, but they basically said, we think that Link is only responsible for this liquidity issue because the issues of malinvestment, illiquid stuff that was in there, connected party transactions, all of the dodgy stuff that Neil Woodford invested in, you can't expect the ACD to stop them doing that. They may be right or wrong, but if they are right, then the corollary is that that means that the fund manager is basically a sovereign adult who is responsible for his own actions. So that would imply that they would have to go and get a restitution order for those other losses from Woodford Investment Management. So I think at some point, if this scheme is rejected by the courts, not sanctioned by the court, there will be some significant expectations and a need to have an adult conversation with the FCA and probably also with Treasury about what happens next.
Mark, thank you very much indeed. Thank you very, very much indeed. In a moment, folks, we're going to hear from Hock. Hock, if you're happy to, it would be super helpful if you were able to kind of give everybody the kind of the key headline messages in terms of the legal argument that yourself and Damien formulated and articulated so effectively last week, in my opinion. So very, very effectively. So please kind of recap on what the legal arguments were, and then please share with us anything that you think that might be helpful for the Woodford campaign group. But before we go to Hock, let me just invite anybody else to come in if they want to, with any comment or question, either directly relating to St. Mark just said, or indeed anything else. So just wave at me, either digitally or literally, if you want to come in. I'm just looking at my screen. Yes, please, Ian Duffield, go for it. Thank you.
Yeah, first of all, something I found what Mark's had to say was very, very interesting. And if you think about what he said about the responsibility of the court, I think was an excellent point. The separation of powers theory says, or in principle, is that it's not for a judge to make law. In practice, they do if they set a precedent. But it's not for a judge to make law. That's Parliament's job. The judge's role, and I noticed that Deborah put a comment in to say she was very disappointed that the judge. I'm sorry, I'm just rolling quickly back to what I think it was Deborah said. That she was very disappointed that the judge's role was to establish whether or not the document was properly written. And in actual fact, that is the judge's role. He's there to make certain that the law, as put in place by Parliament, is applied properly. It's not really his job to set the law. But in fact, in this situation, that's clearly the position he was being put in. I mean, we put him in that position. And I'm not saying that was the wrong thing to do by saying, look, is it not a matter of public policy that the FCA is there to protect consumers? And if so, should you be thinking about that as a principle that Parliament has determined? So it's the will of Parliament, which by definition is the will of the people, and not for you to set the law, but to simply make certain it's been applied. And the downside of that double-edged sword is that if he establishes that scheme of arrangement is in law properly founded, then we end up with the wrong decision in principle being made because of the position the judge was put in. So I did find that sort of fascinating. And the other thing that I'm interested in, again, I agree with what Mark has said. We've talked about this previously about would Link really fight an action when to all intents and purposes defaulted the company. Same applies to Woodford Investment. It's already down to, I think, some £1,000 odd. And I noticed that, and I'll be careful how I comment on this, that a recent loan that the company made to the tune of £1 million, and I'm fairly certain I know who that was to, was written off. So, they've pretty much emptied the coffers there. But what value is there in trying to defend any legal actions that get brought, whether it's against Woodford Investment Management or against Link? But the key issue is, of course, that the length that the counsel for Link went to talking about what they call the ricochet effect, and the effective result that any action against anybody means that they counterclaim against Link, who then all the finger pointing then starts, and they say, well, we've already paid up. And in practice, will that, if the scheme is approved, will that effectively cut dead any opportunity to go elsewhere unless we appeal it and get a win on appeal? So just those observations.
Thank you very much indeed, Ian. Thank you. Mark put his hand up, I think, in response to something you mentioned. And Ruby, yes, I will talk about Post Office FCA in a moment. Okay? Thank you. Mark Bishop.
So a couple of things about Woodford Investment Management. One of the fantastic things about that company is that it's got no money. I can't remember whether its balance sheet is £1,500 or £15,000. Now it's written off that loan, but it's insignificant. And that's helpful because every time a complaint is made against a firm at the FOS, it costs them 750 quid. So it's either 2 or 20 complaints that can take that company down. And putting it in an insolvency process could be tactically quite useful. So
I think it's 1,500 quid, by the way, Mark. Sorry.
Brilliant. So that's 2 people. That's really good. But I would say tactically, it may be worth seeing how this thing plays out before putting in a complaint. Because if, for example, the scheme of arrangement is sanctioned and goes ahead, then your argument would be that the FCA argued and the court accepted that Link was responsible only for failing to stop the liquidity problem. It was not responsible for stopping the fund manager making perverse and self-interested investment decisions. Therefore, those matters must be down to the fund manager. Therefore, you're claiming those losses from the fund manager. So I would personally let that thing play out. The other thing is that, yes, the writing off of the £1 million loan does feel pretty appalling and egregious misconduct on behalf of a director, and probably an insolvency practitioner will attempt to reverse it at some future date. But it's really important we don't make that point in the press. We also shouldn't be talking about Neil Woodford having a CBE taken away, because at the moment, our case is that it is Link Fund Solutions that's to blame, and that Link Fund Solutions is expected to pay up. So our monomaniacal focus is on Link Fund Solutions. But while the judge is deliberating, actually, probably we want to keep a fairly low profile generally. We want to be careful about making any statements, and the media probably don't want to do it. We want to get our ducks in a row for how we're going to handle things according to whether the court rules for us or against us.
Mark, thank you. Just before we go to Hock, Mark, the 77p in the pound bit came up quite a bit last week on Thursday and Friday. Could you just explain to everybody the relevance and significance of the 77p in the pound as far as it being a basis for a response to the idea that yes, but 94% of people want this to happen, so why are you standing in the way of it? Could you just briefly talk about that? I just put the document that was produced for the court in the chat as well about that. Thank you, Mark.
Yeah, I mean, I'll stress I'm not a lawyer, and Hock may have a different view about this. If so, please go with his and not with mine. But it seems to me that we had 2 really big arguments. The first argument was you can't take away somebody's statutory rights by a scheme of arrangement. And the second one is, and even if you could, you shouldn't, because the only reason they voted for this thing is because they were misled. And they were misled in quite a clever way, really. There's nothing in the statement of the explanatory statement by Link that is directly misleading. There may be incomplete and partial and biased information. There's no lies in there. Then if you look at what the FCA has said, what it said about the case, and there were 4 statements made publicly, those aren't exactly lies. At one point they explain that the 77 pence in the pound is where the denominator is the amount by which your losses are greater than the hypothetical loss of somebody who left the fund just before it was suspended in respect of the excess problem of illiquid holdings. So they can calculate what loss is there, 298. You could get up to 235 million, 77%. So it doesn't say it could be as little as 183.5 million. It doesn't say that 298 million is only one head of loss. You may consider you have other heads of loss. So it's not complete, but the problem is they subsequently use it without the denominator being explained. They also make claims that I personally think are almost as bad as the 77 pence in the pound. For example, they say that the calculation of loss made elsewhere, meaning by the litigating firms, these are unrealistic. You're never going to get that money, which is untrue. They say this money that's being promised by Link Group, you would only get it via this means. Well, that's not necessarily true. You might get it by some other means from another party, namely the FSCS, and you get a lot more from them. So it's all really, effectively what happened was the FCA did the dirty work of Link by making claims that Link couldn't make in the letter. And they even really cleverly, they did it in a way that was not exactly dishonest, but where they could foresee that it would be reported in a different way. And Graham Dickinson did an excellent piece of work where he looked at the media coverage, he showed how they'd represented the 77 pence in the pound. And sure enough, almost without exception, it was assumed to be your outstanding capital or your total losses. So it was a very effective piece of work by the FCA, whereby there was 2 steps of separation from the firm, and therefore you could never say that the firm had misled people, which is how you would normally try to defeat a scheme of arrangement. But nonetheless, I think the judge took the point that actually what matters is what the average investor took away from it. And I tried to make the point to the lawyer for Harkus Parker that in a way we had a fantastic natural experiment, because when the FCA statements were put in front of a bunch of personal finance journalists on national newspapers who are surely more sophisticated and more engaged than the average investor in a mainstream retail fund, they misinterpreted what the 77 pence in the pound meant. So, what's the chance of Mrs. Smith from Nuneaton interpreting it correctly? If the personal finances of the Daily Mail can't get it right, close to zero realistically.
Right, thank you. Just before we go to Hock, Professor Krebs put his hand up. Marcus, and then we'll go to Hock.
Yes, so listening to Mark now and also thinking through this case a little bit, this may be a very naive and silly suggestion, so please forgive me if that's already been answered somewhere. But my question would be, has every individual of the Woodford investors raised their case with the financial compensation scheme already? And if they haven't, would there be a point of raising it before the protections are being removed by such a potential judgment? Because by doing that, you're kind of locking your claim in, and whether or not that has got any implications later down the line, I don't know. I don't know what the statute is of the financial compensation scheme, for instance, the financial service compensation scheme. But I guess the question is, have you now got another week and a half sort of window if you haven't got in your claim with them to get your claim in with them? Because if the judge decides to remove it, is there some competing claims that could be argued about? I simply don't know what the legal status is here, but it's an interesting question, isn't it? Because you could open potentially another can of worms with all of this.
Marcus, thank you very much. We're going to go to Hock, who might well cover that point, but I'm sure he's going to cover others as well. And if Hock doesn't cover it, we'll jump back to Mark, who put his hand up when you raised the point. Thank you, Professor Krebs. Hock, can we, before Hock speaks, let's do the obvious things, folks. These guys have put so much time and effort into this case, you would not believe it. Hock was 4 hours on a boat coming across from the Isle of Man, 4 hours in a car driving down to London. The effort being put in by these guys is just exemplary. It really is. Hock, please tell us whatever you want to tell us. Thank you.
Good evening, everyone. I'm a bit embarrassed now. I just want to start with a thank you. Thank you, first of all, to Andy for giving us this gig for Damien, on behalf of Damien and me. Thank you to all of you in the Woodford campaign group for putting your trust in us, because I know and I realise that when we came along and Damien and I said, no, you don't want to do it like that, you want to do it like this. And that was a massive change from where you were at the outset. And it takes a lot of faith to follow 2 guys that you've never heard of before and to put the future in their hands and to abandon to a large degree what you had been campaigning on and the grounds for that for the previous 3-4 years. So I have to applaud that, and it's very gratifying that you gave us your trust. Very early on, I also made it very clear that I wanted you guys to turn up in court and to ensure that the judge personalized this. And boy, did everyone who turned up hit it out the park. So bravo to all of you. And it's a really important factor. And you got the message through to the judge, I think, in a way that Damien and I couldn't do in the way that we were presenting it as lawyers, because lawyers argue legal cases, human beings bring it to life, and that's so important in a case like this. So I can't thank you all enough for trusting us, following us through this journey, and then hitting out of the park on the day. It was amazing. So congratulations to all of you. Now, moving on to sort of just to summarize where we were. The case, what we did in the case, we had a lot of issues that we could have raised. And the important thing was to stay focused on what the objective was, because we could have very easily gone down various different objectives and missed the point. So we were very, very clear in what our objective is, which is simply to kill the scheme of arrangement. That was our Death Star. I think the missile is well and truly shoved up the exhaust pipe, and we're just waiting to see whether it explodes or whether it's a dud. But it's definitely been delivered. I mean, we got rid of a whole host of arguments. As Andy will know, we spent hours and hours and hours researching this, researching that, coming up with arguments, debating it internally, chucking most of it out. And Damien and I chose to focus on where we thought we could provide a clear argument, and leave all the other stuff to the other lawyers to argue. And even the day before, we were practicing what we were going to present to the court as the key arguments. I mean, what most people don't see is what actually happens behind the scenes. It is very much like watching a swan go across water. So if you think Damien was a swan, I was probably the legs underneath the water going like mad. That has been what the last month has been like for us. The two key points that we chose to attack on was the legal point, being the law is the law, it's primary legislation. Can someone point to us where we're wrong, that the court has discretion in the first place? And since we first raised this in early December, there'd been no answer until Tom Smith KC stood up at the very end on behalf of the FCA and pointed to a back end arse end of the comp rules. Something very back end saying, oh yes, and FSCS doesn't apply if a liability has been extinguished by the operation of law. I mean, it's not exactly a strong point, let's put it that way. And then the 77% point is the other one that we chose to focus on, because, as Mark's already said, it goes to the veracity of the vote. Because if that was obtained by a misselling of the picture, then that undermines the validity of the vote, and that goes to whether the judge should exercise his discretion, assuming he has a discretion, to do that. And I have to say, absolutely bravo to Karen, because I mean, you guys won't know this, but she set the trap the day before on the Wednesday afternoon with the FCA. And she emailed Willie Walsh at the FCA and challenged him on his evidence. And he came back and said, I don't wish to change a word of my evidence. And boy, is that going to come back and haunt them. Because after all the arguments about the 77 pence in the pound, their defense of it, saying it was a proper estimation, it was fair, everything else is defended, blah de blah. Right at the death, Tom Smith then conceded that the 298 million was just the loss of the first mover advantage, and it was, to use his phrase, a subset of the total losses that investors have suffered. That is a concession that the 77 pence in the pound, as promoted by the FCA, is a fabrication in legal terms. That is just amazingly bad for the FCA. So bad that I don't know whether everyone else noticed who was watching. The judge actually said, I don't want to leave that in submissions. I'd like that to be backed up and confirmed by a witness statement by Willie Walsh, by the FCA. So there is going to be some humble pie eaten by the FCA for standing firm, forgetting to mention this very key fact to the judge, and then having to explain it after the event. So let's go back to where we were on, I think, the Monday or Tuesday before the hearing. We, in the legal teams, received an email from the judge saying, I would like to set out the running order and organise the hearing for Thursday, Friday. And he gave some suggestions. We then went back and organised how it was going to run. But at the end of his email, he said, this is the way I'd like it to run, opening from the company, the objectors, a response from the company, and then I'd like to hear last from the FCA, and then I anticipate on the Friday afternoon when it's all done, I'm going to give you judgment with reasons to follow later. Then he received the skeleton arguments from all the parties, and the first thing he said when we all got into court was, let's be clear, I did say I was going to give judgment on Friday afternoon. I don't think I'm going to do that now. It's most likely I'm going to reserve judgment. And then after everyone's had the toing and froing and he's heard everything in the court, he finished by saying, right, now I'm going to reserve judgment for 2 weeks. And then I'm going to do an embargo judgment. And then at the end of that, I think this is going to be appealed. And I would then, at that point, invite the parties to address me on appeal. Now, he's not even announced this decision yet, and he's already talking about an appeal. Having 5 minutes before had the FCA admit that the 77 pence in the pound was a load of utter misleading bollocks, in essence. So we have a very interesting situation. And I've told Mark, I haven't bothered Andy because he's been dealing with his personal family matters. But I am, and Damien's the same mind, I'm quietly hopeful, touch wood, okay, that we might have pulled the stunt off, but we don't know yet, okay? We'll just have to wait and see. But I think, come what may, the TTF team, and it has been a team, and there's been massive input from all concerned. So it's not just Damien and me, it's not just Andy, it's not just Mark. No, we've had so much help from all of you. I think you can all be very proud of the show that you put on. And let's just wait and see what happens the next couple of weeks. And no, let's keep on fighting on. Thank you very much.
Well, thank you very much indeed. That's such a lovely, positive way to end the session. We'll just check in to see if there's any other business before we do wrap up. But thank you all so much. It's been one hell of a journey, hasn't it, over the last couple of months or so. Mark Bishop's put his hand up. We'll go to Mark and then we'll go to anybody else for any other business. Then we'll look to bring things to a nice close. Mr. Bishop, thank you. Mark.
Okay, thank you. So, Andy, you asked me to deal with the issue of the FSCS if Hock didn't.
Yes.
And I don't think Hock did, so I will briefly deal with it now. Of course, I'm not a lawyer. I'm not giving you legal advice. I'm just going to express an opinion. The opinion is you don't need to write to the FSCS, and you just annoy them if you did. And the reason is that you've only got a claim at the FSCS if you have either litigation or a financial ombudsman award, or in theory, you're a beneficiary of a restitution order obtained by the FCA, albeit that they would handle that for you, and the firm has gone into default. At the moment, you haven't got those things. That's really the reason why we had the hearing last week. So the firm isn't in default, so you haven't got a reason to go to the FSCS. A separate issue is about the Financial Ombudsman Service. I appreciate that some people who signed up for group litigations may not be able to go to the Ombudsman and may not want to, but those who haven't, generally you have 6 years from the actual omission that you're complaining about, or you have 3 years from when you can reasonably be expected to have found out about it, to have done two things. The first is complain to the firm, and the second is then take the decision notice or the absence of decision notice within 8 weeks to the Ombudsman. So the question is, do you have to go to the Ombudsman yet? Well, the fund was suspended about 4.5 years ago, and of course some of the acts and omissions occurred more than a year and a half before the fund was suspended, but they were really the beginning of a process, and that process continued until the fund was suspended. So probably you're not under time pressure to complain. And personally, I would say you're in quite a strong position not to complain, given that the FCA, no, the FOS has been basically pausing its investigation of existing complaints for all of these years. It might be to your benefit to see what happens about the sanction hearing, whether there is an appeal, how it goes, and also ideally to see how those initial complaints are dealt with by the Ombudsman before putting in your own complaint. And personally, I would say I think the risks of not complaining to the Ombudsman at this point are quite low, and the benefits of waiting what might only be a few weeks or months could be quite high.
Mark, thank you very much indeed. I've had a question regarding the post office and FCA event. So allow me just to elaborate on that. So the title of the post office and FCA event is what are the similarities between the post office and the Financial Conduct Authority? Now, to actually understand what the similarities are, you need to come to the event, but let me just paint the picture. There are all sorts of issues that have caused the post office to behave the way that it has. Conflicts of interest, commercial capture, incentive schemes, a degree of malevolence, a willingness to cause harm to others. There's been greed, there's been collusion and cover-up. You could argue there's been corruption. There's been all sorts of horrible things going on that have resulted in the post office being the way that it is.
Andy,
Now, yes,
may I add one more,
please do.
which I think is central to this? It's protection of the brand.
Thank you very much, Sean. That's so good. Please elaborate on that point. That's such a powerful point because it's come up in all sorts of places. I've heard the people explain why Met Police behaves the way it does because it's protection of the brand. It applies to the FCA, it applies to the post office. Please just elaborate on why that's such an important point. Thank you.
Okay. So I'm not going to elaborate more on the post office itself, but it has been said that the motivation as to why the post office continued with its disastrous route was to protect itself, its brand, in the public face. What we have here is a disaster, a financial disaster, which ran unchecked, and the various parties who were meant to keep Woodford in check failed to do their job effectively. Amongst them is the FCA. And what has absolutely become very clear from this hearing is the scheme of arrangement was the result of a 7-month negotiation between the FCA and the company. And amongst all of that, they put together all the key component parts. The FCA then mercilessly promoted this, and the end result would have been, had this gone unchallenged, would be all over the press that the FCA has put the scheme together with glorious success and recovered 77 pence in the pound for all concerned. Aren't we heroes? And then history would be rewritten in that context, and all the other issues that you have been raising and being concerned about, and looking at your own genuine numbers, that's not really 77 pence in the pound. Now, on the numbers that we calculate, it's between 5 and 10 pence in the pound in general terms, and that's far different. So the reason why this has been pushed so hard right up to the court and all the way through to the end, until it became overwhelmingly obvious that the 77 pence in the pound, to the judge who was directly questioning their counsel in the last stint, I mean, it was just hopeless to maintain that at that point. But why would they do that? Because it is to protect the brand of the FCA. Mm. And that is why I mentioned that as a common theme. Thank you.
Thank you. Well said, sir. Well said. So if you imagine an A4 piece of paper, right? Imagine an A4 piece of paper with a line down the middle of it. One column, one half is all about the characteristics of the post office, and the other half of the page is characteristics of the FCA. On the post office column, you'd have conflicts of interest, revolving door, regulatory capture, commercial capture, greed, self-interest, protection of the brand, collusion, cover-up, malevolence, and all those other things. And trust me when I tell you that we TTF have probably got a better understanding of the flaws within the FCA than any other organisation in the country. I don't think there's any organisation out there that comes anywhere close to the depth and knowledge of the FCA for all kinds of reasons, including, of course, the work of the All-Party Parliamentary Group that we provide the Secretariat for, which has carried out a very extensive evidence gathering session about the FCA. So there's an argument that most, if not all, of the flaws that characterize the post office are also present in the FCA. And that's why we're running that event. And that's why we think it's very important, because if people can get their head around what's wrong with the post office, and if they can come to realize that there are important similarities between the FCA and the post office, they'll come to understand why there are so many hard cultural flaws within the FCA that it's going to become increasingly difficult for it to be fixed. And frankly, if you study the Woodford case from its very, very beginnings to now, just taking the Woodford case alone, let alone Connaught, let alone Premier FX, let alone Hendy, let alone Blackmore Bond, let alone LCNF and all the others, if you just studied Woodford and the FCA's handling of it from beginning to end, including putting out communications that's misleading and choosing not to respond to requests from us to fix that confusion, you will come to the conclusion that there are remarkably worrying similarities. Now, I'm stating this knowing the session's been recorded, and I'm going to make the point as clearly as I can. I, Andy Agafangelo, do firmly and solemnly believe there are worrying similarities in the characteristics of the post office as revealed through that ITV program and everything we've learned since, and the way the Financial Conduct Authority operates, based upon the evidence I have seen with my own eyes and the conversations and testimony I've had from literally hundreds and hundreds of people. We're going to go to Mark Bishop, then we'll go to any other business, then we'll bring our conversation tonight to a close. Mark.
just before the end, there's one thing I really wanted to say, and that is, how grateful I am, and I'm sure we all are, to Hock and to Damien. I remember at one point, I think as we just finished the second day, Hock was looking at the benches on the other side and saying, look at this, they've got X number of KCs, X number of partners, X number of fee earners. And we're talking about, how much does it cost per hour? £20,000, maybe more, in legal fees alone. And this is just for the 2-day hearing. They probably spent £250,000. And that's remarkable, They had so much kind of arraigned against us. But I actually thought, well, their team didn't land the punches, ours did. It shows you when you've got a team that is small, focused, determined, and you've got right on your side. Sometimes David can beat Goliath, and I'm not saying we have beaten Goliath because we don't know the result yet, but I actually think it is quite possible that we may have done. So thank you very much to both of them.
Fully supported by me and absolutely everybody else. Any other business before we wrap up? I just wave something at me if you want to come in. Alan Pyatt, yes, please, sir. Thank you.
Right, I got some. Well, so I've been sitting here trying to get some questions out. Right, I've got some very important questions for Hock. Okay, so I'd like to thank Hock, and Damon. A couple of points. So let's say the judgment goes against us. I assume then the TTF would appeal, and that's the Court of Appeal Civil Division, from what I've just understood. So that's point one. Would we appeal? Point two. What sort of timeframes, if they appeal or we appeal, do we expect it to go to Court of Appeal? If we TTF go to Court of Appeal and lose, can Link say, we've had to come to Court of Appeal, here's our legal costs, TTF, pay up? Yeah? And if it fails, there's another one, if it fails at the Court of Appeal, does it go to the Supreme Court or is it dead in the water?
Thank you, Alan. Hock, would you like to respond to those questions? Thank you.
Well, I have actually already been giving a lot of thought to this situation over the last couple of days. And funnily enough, I was talking to Damien about it at lunchtime today. And it's not a straightforward issue. First of all, we need to wait and see what the judgment actually says. If we lose, we then have to put in the grounds of appeal. We'll need leave from the court to do that. We also need to argue about the cost situation, because the reality is TTF doesn't have the money to pay any adverse costs. There are going to be all sorts of arguments against us, saying that we only represent 7% at best because 93 voted in favour if the court finds in their favour. And therefore, they're going to be saying, no, you guys should bear the risk of the appeal. So they're going to be, and then if they lose, would they appeal or would they just go away and rejig the scheme? I mean, there's so many potential permutations, but at this stage, I think we'll be wasting our breath trying to nail down each one to the nth degree. No, Andy hasn't. I haven't had a chance to talk to Andy about this yet, but no, Damien and I were talking about this. I mean, we've both agreed that we will run any appeal pro bono. Okay, if it comes to it. So we're not going to charge you guys for running any subsequent appeal. We'll just carry on doing it.
Thank you, Hock.
So,
that's really kind.
so we just need to wait and see. But the one thing you do know is we're going to be there. So come on, May. Let's take it one step at a time.
Here. I'll tell you what, folks. It's not often in life you have people who don't have to be generous being that generous. So let's show our appreciation once again, and let's bring things to a close. Whatever happens, folks, we can look back and know that we've done everything we possibly can. I love the way that Hock put it earlier. You know, the weapon has been built, it's been delivered, it's halfway up the exhaust pipe. Let's wait and see if it actually explodes. And who knows, if it does, it's going to be a pretty stellar explosion that's going to leave a lasting impression in many places for a long time. We'll wrap it up there, folks. Hock, All, thank you very much indeed. Good night all. Thank you.
Good night,
Thanks,
everyone.
Andy.